Today I had my ninth Supreme Court argument. I've been in law for 30-something years now. Started out with the United States Justice Department, and I came to Jones Day in 2001, part of the Issues and Appeals group, so my main focus has been on appellate work, usually involving public policy issues and constitutional questions involving the federal government. Today's case where 10 California teachers challenged this regime that exists in California and about 20 other states, which says that even if you're not a member of the union, you can be compelled to give the union money. And since the union is an advocacy organization that has a very specific viewpoint on controversial public issues, we argue that that violates the First Amendment because you can't compel somebody to support an organization with which they disagree or just simply don't wish to subsidize. The particular issue was this regime had been upheld in a 1977 Supreme Court case called Abood, and the court agreed to reconsider whether that precedent should be overruled because of the stark violations of speech and association rights involved in this compelled subsidy regime. Well, we had read this decision called Knox that came out about 4 years ago, which expressed serious doubt about the correctness of the analysis in Abood upholding this regime. And we thought it would make sense, because I had always thought Abood was wrongly decided, to see if we could mount a challenge and have Abood overruled. We partnered up with a public interest group in the district called the Center for Individual Rights and came to represent the 10 teachers who I previously described, who were not union members and objected to this regime. The prior cases involving this very particular issue had divided the court 5-4, and so 4 members of the court, all of whom were appointed by Democratic presidents who had dissented in the prior cases, were obviously skeptical about our argument and were thorough in their questioning of our positions. I thought that I had an opportunity to make thorough responses, which I think exemplified the point that I was trying to make, which was this case of Abood could not be squared with basic First Amendment principles articulated by the court's other precedent. So in order to restore predictability and consistency to the court's jurisprudence, it was important to overturn Abood.